alumnus of the School of Law at SASTRA University, and it is my pleasure to welcome you all to Jus As They Speak, an academic initiative by the School of Law at SASTRA University as part of the Nani Palkiwala centenary celebrations this year. And it is my pleasant task to welcome Justices Nagamuthu, former judge, the High Court of Madras, and senior advocate, the Supreme Court of India, for today's talk on the making of a sessions trial, which is divided into two parts, and this will be the first part of his lecture. Justice Nagamuthu is not new to Sastra University. We have had the opportunity of listening to him on multiple occasions. And what remains fresh in my mind as a student is his lecture on criminal law and the Constitution in 2016, which was so well received and so intricate in its detail and presentation. Justice Nagamuthu began his initial days in the trial side, the criminal side practice in the Tiruchi and Tanjavur districts, slowly spread his wings, and ultimately was elevated as a judge of the Madras High Court in 2007. I must, with the permission of Justice Nagamuthu himself, advert to an article which I had an opportunity of writing for a leading legal journal in the time of his retirement in 2017, recounting his judgments. And each of the judgments is a great contribution to criminal law. And the students of the School of Law have greatly benefited by interning under Justice Nagamuthu when he held the office of a judge, and later also reading his judgments. And his order has often provided guidance to criminal law itself. The judgments in S.A.K. Amal versus State by Inspector of Police, which unraveled the proprieties of the reference by a sessions judge to the High Court on questions of law. Then we had the state represented by Inspector of Police Chennai versus K. Prabhu, which dealt with the concerns relating to how the media was interacting with criminal jurisprudence. Then the judgment in Chinnathambi versus State on the nuances of the distinction between judicial and non-judicial orders, shedding clarity on the scope of statutory approaches to the same. And the very landmark judgment in Jacqueline Mary versus Superintendent of Police Karur, where for the first time in this state, a transgender was reinserted in a police recruitment process, and history was made therein. Many other judgments stand to his credit, and many of those judgments, in fact, one of his last judgments in P. Duraisamy versus State, represented by the Secretary to the Government, where the much talked about practice of magistrates granting bogus birth certificates was referred to. Then, of course, was an earlier judgment in P. Veerabharati versus State of Tamil Nadu about the existing system of remissions is a very important judgment. And of course, the full bench judgment in State versus Velayan back in 2011 on the period spent on parole. Without taking much more time, I must also add with a sense of great happiness that Justice Nagamuthu, after retirement, was designated a senior advocate of the Supreme Court in 2018 and has been contributing to the growth of law at the national level itself. And the recent judgment on the interface between the Criminal Procedure Code and the Drugs and Cosmetics Act, in fact, the judgment has come yesterday, and it speaks volumes of Justice Nagamuthu's contribution as an amicus curiae appointed by the Supreme Court in that matter. And we are all years awaiting to hear Justice Nagamuthu on this subject. And now it is my pleasure to hand over the mic to him.
Good morning. Am I audible?
Yes.
Yeah. Yes. My dear Chancellor and Vice Chancellor of Sastra University, the Dean, the faculties, students, and all other dignitaries. Very good morning to all of you. Indeed, I am extremely delighted to be in this webinar organized by the Sastra School of Law as a part of Nani Palkiwala Centenary Celebrations lecture series. The topic today is making of a sessions trial, part 1. Part 2, we have planned to do it later. I am very happy to meet more particularly the students of the School of Law, SASTRA University, after a gap of about 4 years. Without spending more time on the introduction of the topic, let me straight away go to the subject today because of the paucity of time. The topic given to me today for my lecture is making of a sessions trial. I am sure that there are legal luminaries and advocates participating in this webinar, but I tell all the friends that my focus today is going to be only on the student community, because the lawyers and legal luminaries have got other forums where they can interact and learn many nuances. But students rarely get this kind of opportunity. Therefore, I am going to concentrate on the students, and as a result, you will realize that what I am going to say today are all only fundamentals of criminal law in respect of sections of trial. So, my dear students, I think that you have already been taught the Code of Criminal Procedure. The trial before court of session is dealt with in chapter 18 of the Code of Criminal Procedure. Chapter 18 speaks of the trial before a court of session. As a student, I think that many of you would not have even seen the actual proceedings going on in session courts. Therefore, I must tell you as to what a court of session is and as to how the trial is conducted. This chapter, as I already pointed out to you, is relating to the procedure of trial before a court of session. Then what is a court of session? For that, student must go to section 6 of the Code of Criminal Procedure, which classifies the courts. See, section 6 reads like this: besides the high courts and the courts constituted under any law other than this court, there shall be in every state the following classes of criminal courts, namely courts of session, judicial magistrate of first class, and in any metropolitan area, metropolitan magistrate, judicial magistrate of second class, and executive magistrates. My dear students, please know that in our state and mostly in other states as well, the judicial magistrates of second class courts have been abolished. All the courts have been now upgraded some 25 years before as judicial magistrates of first class. So in our state and as well as in the other states, there are only two classes of courts. One is court of session, the other one is judicial magistrates courts and the metropolitan magistrate court, so far as metropolitan area is concerned. Now we are concerned today for our lecture about the court of session. What is a court of session? That is defined in section 9 of the code. Section 9 states that the state government shall establish a court of session for every sessions division. So for every sessions division, there shall be a sessions court. Then what is a sessions division? That is dealt with in section 7, which says that every state shall be a sessions division or shall consist of sessions divisions, and every sessions division shall for the purpose of this court be a district or consist of districts. So a state shall be divided into various sessions divisions, mostly in tune with the revenue district, mostly. So every such a sessions division, as declared by the state government under section 7, shall have one sessions court as per section 9 of the Code of Criminal Procedure. It is mandatory. Please kindly see the language of section 9. The state government shall, please underline this word shall, establish a court of session for every sessions division. Therefore, in every sessions division, there has to be necessarily one sessions court. Please understand this first. Then, next paragraph, next subsection 2 says, who shall preside over the sessions court? Subsection 2 says, every court of session shall be presided over by a judge to be appointed by the High Court. So every session court shall be presided over by a judge who shall be appointed by the High Court. So friends, please know that every session division shall be therefore presided over by a session judge of a sessions court. Then subsection 3 speaks of the High Court may also appoint additional session judges and assistant session judges to exercise jurisdiction in a court of session. So in addition to the court of session or a session judge, the High Court may also appoint any number of additional session judges as well as assistant session judges. So in common parlance, the court of session, namely the judge who is presiding over a court of session, is called as principal session judge, and all the other judges in the cadre of session judge are known as additional session judges. In the cadre of subordinate judge, there are judges appointed who are known as assistant session judges. These are the three classifications so far as session judges are concerned. Now, with this idea, let us go to chapter 8, which speaks of trial before a court of session. What is court of session? I already told you. Now, how the trial is to be conducted before a court of session is our topic. Section 225 states that in every session's trial before a court of session, the prosecution shall be conducted by a public prosecutor. So prosecution shall be conducted only by a public prosecutor as per section 225. Now, first of all, before knowing as to how the case is opened by the public prosecutor, we should know as to how the case reaches the court of session. This is very, very important. Though it is not covered in our topic today, only as a prelude, I want to tell you as to how it reaches the court of session. You all know very well that there are two methods by which a criminal case can be brought to the court. There are three methods virtually. For our discussion, let us take up only two methods. As you all know, as per chapter 12 of the Code of Criminal Procedure, as and when a crime is committed and a cognizable offense is committed, case is to be registered under section 154 of the code that we call as FIR. Then investigation is to be conducted under the said chapter. And finally, a police report, final report, is to be filed before the magistrate, not before the sessions court. Please understand, friends, a charge sheet cannot be filed. That is final report. We call it as charge sheet. A charge sheet in a criminal case investigated by the police cannot be filed directly before the court of session at all, except in certain cases where such exception has been carved out. We are not today concerned with the exception because that is not our topic. So before a court of session, charge sheet cannot be filed. Similarly, in respect of offences, any offence, private complaint also cannot be filed directly before the court of session. These are the matters which are to be filed only before a magistrate having territorial jurisdiction over that area. Now let us take the case of a police report, namely charge sheet case. A charge sheet is to be filed before the court of session, before the magistrate concerned, and that magistrate is to take cognizance of the offences under section 190 of the Code of Criminal Procedure. So the purpose of filing a final report is to inform the court that here is a case which you have to proceed further. The magistrate, on considering the police report and the documents filed therewith, if finds that there are materials to proceed further, then he will take cognizance. That process is known as order taking cognizance under section 190 of the Code of Criminal Procedure. What actually the term taking cognizance is has not been defined anywhere in the code. But by judgment law, we know that taking cognizance means applying the judicial mind by the magistrate and to decide to proceed further against in the case. So this process is known as taking cognizance as dealt with in section 190 of the code. So after taking cognizance, what the magistrate has to do is that under section 204 of the code, he has to issue summons to the accused for their appearance in court. So that order we call as accused summoning order. My dear students, please understand. Suppose a policeman files a charge sheet only against 5 accused, for example, and if the magistrate on going through the papers, namely the report and the document filed therewith, if he finds that some more people who have been omitted, against whom also there are materials, the magistrate is empowered under section 204 of the code to summon those accused as well. So this is the power of the magistrate to add any more person, to summon any more person as accused other than those persons against whom the final report has been filed by the police. Then power of the magistrate to order for further investigation, etc. I'm not going to deal with that today. Now, after summoning the accused and after their appearance in court, it is for the magistrate to supply copies of all the documents upon which the prosecution is going to make reliance. What are those documents which are to be supplied to the accused free of cost? FIR, statements of witnesses recorded under section 161 of the Code of Criminal Procedure, documents upon which the police like Magazar, etc., sale deed, or any other document seized during the course of investigation, all those documents upon which the prosecution is going to rely on during the course of trial are to be supplied to the accused free of cost by taking copies. Now, previously, before a judgment of the Supreme Court in V.K. Sasikala's case, the courts were of the view that the accused is entitled for those copies of those documents upon which the prosecution is going to make reliance, not on the other documents. But in V.K. Sasikala's case, decided somewhere around 2012, I believe, the Honorable Supreme Court has held that the trial should be fair as guaranteed under Article 21 of the Constitution of India, and therefore, in order to achieve fair trial, in order to afford opportunity to have fair trial, the accused should be furnished with copies of all the documents which form part of the court case records if he makes an application for the same. This was a historic judgment, in fact, made by the Honorable Supreme Court, declaring the right of the accused to have copies of all the other documents, which if he feels are in his favor. So copies are furnished under section 207. After copies are furnished under section 207 of the code, the magistrate has to now examine whether the case can be tried by himself or the case has to be committed to the court of session. This is dealt with in section 209 of the Code of Criminal Procedure. Section 209 of the Code of Criminal Procedure code mandates that if one or more offences in the final report makes out a case which is exclusively triable by court of session, then it is mandatory for the magistrate to commit the case to the court of session. That is what section 209 says. Now, I said that as dealt with in section 209, cases which are exclusively triable by court of session are to be committed to the court of session. What are those cases which are exclusively triable by court of session? Please, my dear students, for that purpose, you have to go to the first schedule to the Code of Criminal Procedure appended at the end of the code. There, you will find the classification of the offences into cognizable or non-cognizable, bailable or non-bailable, and by what court it is triable. If you look at this schedule, you will find that there are certain offences which can be tried only by the court of session, that is exclusively by the court of session. For example, you take the case of a murder. The schedule says that it shall be tried exclusively by court of session alone. So this is the examination to be done by the magistrate under section 209. Then he will commit the case to the court of session when he finds that there are offences, either one or more offences in the case are triable exclusively by the court of session. Then he will commit the case to the sessions court. So that is how the case comes to the court of session. This is the one way. There are two other methods by which also a case can be brought to the court of session. Though the offences are not exclusively triable by court of session, I have already told you that if the offences are exclusively triable, not all the offences, one or more, are exclusively triable by the court of session, it is mandatory for the magistrate under section 209 to commit the case to the court of session. No doubt about that. Now, in a given case, though not even a single offense is exclusively triable by court of session, even then the magistrate is empowered to commit the case to the court of session as provided in section 323 of the Code of Criminal Procedure. Please, my dear students, please make a note of this provision also. This says, if in any inquiry into an offense or a trial before a magistrate, it appears to him at any stage of the proceedings before signing the judgment that the case is one which ought to be tried by the court of session, he shall commit. Suppose for any reason if the magistrate feels that this case needs to be tried by the court of session, though it is not a case exclusively triable by court of session, the magistrate is empowered to commit such a case also to the court of session. That power is given under section 323. What are those cases? Under what circumstances the magistrate can transmit the case, commit the case to the court of session is a different subject. And for today's discussion, you need not confuse yourself with this. You please know that there are two provisions. One is under section 209 CRPC, and the other one is under section 323. The case can be committed to the court of session. That is how the police case comes to the session court. Similarly, if it is a case instituted on a private complaint before a magistrate, the magistrate shall follow the procedure under section 200, 201, 202. And if he does not dismiss the case under section 203, the magistrate will again summon the accused on 204, supply copies under 208, and commit the case under section 209. So these are the two sources by which the case comes to the court of session. Now, let us come to the next stage. Very well. The cases have now been committed to the court of session. What the court of session has to do at that stage? These are all pre-trial procedures being followed by the sessions court. So after the case reaches the sessions court, by way of committal, what the session judge has to do is dealt with in section 193 of the Code of Criminal Procedure. Under 193, it has been declared that the court of session has got no original jurisdiction at all to take cognizance of any offense directly. That is the reason why I told you that police report, namely charge sheet, cannot be straightaway filed to the court of session. Similarly, a private complaint also cannot be straightaway filed before a court of session for want of original jurisdiction. Section 193 of the code confers jurisdiction on the sessions court to take cognizance of any offense, not on any police report, not on any private complaint directly filed, but only if the case is committed to that court by the magistrate, either under section 209 or under section 323. Please, friends, let me read section 193 for your benefit. I quote, except as otherwise expressly provided by this court or by any other law for the time being in force, no court of session, please underline this. I think students have got CRPC book in their hand, please underline. No court of session shall take cognizance of any offense as a court of original jurisdiction. This is a bar for the sessional court to take cognizance of any offense directly as a court of original jurisdiction, unless the case has been committed to it by a magistrate under this code. So if only the case is committed to the sections court, as I have told you, either under section 209 or under section 323 of the code, the magistrate cannot take cognizance. If it is so committed, the sessions judge can take cognizance under section 193. So after taking cognizance under 193 of the code, what next? To be done by the sessions court. It says section 194 says that an additional session judge or an assistant session judge shall try such cases as the judge of the sessions division may, by general or special order, make over to him. Please underline this word again. When I dealt with section 209 and 323 of the code, I told you that the magistrate has to commit the case. So that is a judicial order passed by a magistrate committing the case. But here under section 194, the session judge, after taking cognizance, makes over the case to the additional session judge. So the session judge does not have jurisdiction to take cognizance at all. He has been empowered only to try a case which has been made over to it by the court of session, or if it is transferred by a special or particular order by the High Court. So otherwise, there is a vast difference between the power of court of session, namely principal session judge, and an additional session judge. The court of session, namely principal session judge, can take cognizance on a case committed to it under section 193. This power is not available to an additional session judge. An additional session judge can only try a case, not the power to take cognizance. It can only try a case if it is made over to it by the sessions court. That is how the case is now before the court of session. Now let us come to the main topic for our today's discourse. Let us go to this chapter, that is 225. 225 say that in every, now please friends, keep in your mind, case which originated in the police station, culminated in a final report, namely charge sheet before a magistrate. Magistrate, after taking cognizance, has committed the same to the court of session. Now court of session under 193 has taken cognizance. Now the case is before the court of session for trial. How the case is to be tried? Section 225 says that in every, who shall conduct the case? In every trial before a court of session, the prosecution shall be conducted by a public prosecutor. Here again, please make note of the term shall. So before a court of session, the prosecution can be conducted only by a public prosecutor appointed, not by anybody else. No private advocate engaged by a party can appear and conduct the case before the court of session. This is very, very clear from the reading of section 225 of the code. Please, therefore, my dear students, understand that before a magistrate court, whether a private person can conduct a trial is dealt with. There, in certain exceptional circumstances, it can be done. But before a court of session, no private counsel can conduct a prosecution case. It may be true that the case originated by way of private complaint before a magistrate, where the case was conducted by a private counsel. Once it reaches the court of session, the private counsel engaged by the party has got no right to appear in the case and to conduct the prosecution. The prosecution can be conducted only by a public prosecutor. That is what section 225 says, who is a public prosecutor? Please kindly come to section 24 of the code. A public prosecutor is the one who is appointed by the state government for the district. Please let me read section 24, few subsections alone. Subsection 1, that for every high court the central government shall appoint, that is for the high court. Subsection 3, for every district the state government shall appoint a public prosecutor and may also appoint one or more additional public prosecutors for the district. So appointment is to be made by the government for a district. So for each sessions division, which is known as judicial district, there has to be one public prosecutor necessarily appointed by the government. It is mandatory. There has to be one public prosecutor. Then the government may also appoint any number of additional public prosecutors for the same district to do cases in a particular court. So the public prosecutor is the one not engaged by any private party, but the one who has been appointed under section 24 of the code. What are the qualifications for appointment? What is the procedure for appointment of a public prosecutor are all dealt with in section 24, and as well as in section 25 about the appointment of assistant public prosecutor, etc. We are not concerned with that today. So such a person appointed by the government as public prosecutor shall alone do a case before a court of session. This is what section 225 of the code mandates. Now, how he has to do the case? That is, you go to the next section 226. Opening case for prosecution. When the accused appears or is brought before the court in pursuance of a commitment of the case under section 209, the prosecutor shall open his case by describing the charge brought against the accused and stating by what evidence he proposes to prove the guilt of the accused. So the initial burden of a public prosecutor is to open the case. What he has to say is that on an appointed date, he should tell the judge that these are the charges which you have to frame against the accused, and these are all the evidences which I am going to place before you in support of the charges, and therefore please frame charge. So he has to open and tell the judge in a brief manner as to what is the case against these accused who are before the court. So the accused should be there before the court. Please understand that also. When the accused appears or brought before the court, in the absence of the accused, this cannot be done. So the presence of the accused before the court is mandatory unless his presence is dispensed with under section 317 of the Code of Criminal Procedure. So the public prosecutor shall open the case. This is the first stage of the proceeding before a court of session, that is opening of the case. In other words, describing the case, narrating the case, as well as the evidences to the judge by the public prosecutor. After this is over, an important stage now comes. That is, under section 227, discharge. My dear students would have heard that the accused is discharged in this case. You could have seen this kind of news in newspapers. This is dealt with in section 227. What is discharge? Discharge means without proceeding further, without examining any witness, the accused is let off. He is freed from the clutches of law. That is discharge. That is without trial, without examination, which means without examination of any witness, without any judgment, he is let off. That process is known as discharge, that is dealt with in section 227. When a person can be discharged, if upon consideration of the record of the case and the documents submitted therewith, and after hearing the submissions of the accused and the prosecution, the judge considers that there are not sufficient grounds for proceeding against the accused, he shall discharge the accused. So in this provision, every word employed carries its own important meaning. Closely look into this provision. Now, at that stage, after the public prosecutor has narrated the case under section 226, what the session judge has to do at this stage is so meticulously, he has to consider the record of the case. What are the records? Like final report, statements of witnesses, documents produced along with the same by the police. Now, record of the case. This term record came to be confused by various courts in this country. The question arose before various courts whether at that stage accused can produce his own documents in defense. Was the question. Several courts took different views. Finally, the Honorable Supreme Court has now held, very long before it was held, that the Court of Session at that stage cannot permit the accused to produce any document. So the court can look into only the documents which form part of the case record as produced by the police. This is what the law laid down by the Honorable Supreme Court. The importance of the law I will tell you a moment later after completing the reading of section 227. So first thing is upon consideration of the record. I have told you record means record of the case, nothing else. The accused cannot produce any document from out of his own pocket and say, you please look at this document and discharge me. That he cannot do. Now, proceeding further. And the document submitted therewith, and after hearing the submissions of the accused and the prosecution, so oral submissions or written submission, anything, whatever it is, the judge considers that there is not sufficient ground for proceeding. So after having gone through the records of the case, after having gone through the documents filed along with the charge sheet, the court has to, at that stage, only consider. Here there is no evaluation of anything. There is no detailed analysis of the materials available on record. What the court has to see is it is only consideration. What the court has to consider, whether there are sufficient grounds for proceeding against the accused. So that is the only consideration. If the court finds that absolutely there is nothing against the accused, then it is mandatory that the court shall discharge the accused without proceeding further, without trying him. This is an important stage in every case. So at that stage, I want to repeat, because you should be very thorough with this provision, that the session judge has to consider the case record and the documents filed therewith. And on such a consideration, if the session judge finds that there are no grounds to proceed further against the accused, either one or more of the accused, the session judge shall discharge such accused. This order is known as discharge order. Now the Supreme Court in State of Orissa versus Debendranath reported in AIR 2005 Supreme Court page 359 by a 3-judge judgment has categorically held that at that stage the accused is not entitled to produce any document. Why I am saying this is for this purpose. Suppose here is a case where it is said that the occurrence had taken place in Tanjavur, and this accused, particular accused, let us say A5, the fifth accused, was also present on the spot, and he also participated in the commission of the crime. This is the final report. Witnesses have said, yes, he was present here. He also participated. Suppose this particular accused A5 has got record to show that on that particular day, he was in the United States of America and he was not at all in Tanjavur on that particular date. He may try to prove the same by producing his passport and all his other travel documents like visa and his records for his stay in USA, etc. If these documents are accepted by the court as true or genuine document, then it goes without saying that he was not present in Tanjavur on the date, and therefore the prosecution case is false. In such an event, the accused can be discharged very well, but it cannot be done because, as per the mandate of section 227, at that stage, the accused cannot produce these documents at all. Then what is the remedy for him? The remedy for him is either to challenge the proceedings before the High Court under 482 of the Code of Criminal Procedure, where the High Court can receive these documents and quash the case. So there is a vast difference between the power of the Honorable High Court under section 482 of the Code and the power of the session judge under section 227. Under 227, the power is so limited to look into only the case records and the documents filed therewith and not to receive any document from the accused. But if the party moves the Honorable High Court under 482 of the Code, the High Court can very well receive these documents which are unimpeachable. That is the only qualification. If there are doubts regarding that document, then the court will not act upon that, even the High Court. The High Court will receive and act upon unimpeachable document and quash the case. That is a remedy for the accused. Suppose he doesn't want to go to the High Court. What is the next remedy? He has to face the trial, and at the time of trial, he can produce all these documents. And at that stage, while pronouncing the judgment, the Sessions Court will appreciate these documents as evidence, and acting on that, the Sessions Court will acquit him. So that is the remedy available for him. Now we are at the preliminary stage. Under section 227, the court is concerned only with a prima facie case. If there are reasonable suspicions against the accused, that suspicion arises out of the records available before the court, then it is mandatory for the court to frame charges. If the court finds that there are no materials even to raise reasonable suspicion that this person would have committed the crime, only in such an event the court shall discharge the accused. Please be informed of the difference between the discharge and acquittal. Discharge under section 227 means without proceeding further, without examining any witness, on the ground that there is no material at all against the accused, to make out a prima facie case, letting off the accused. This is discharge under section 227. I think that I need not labor more on section 227. Let us go to the next provision, 228. That is framing of charge. Suppose the court, on considering the court records and on considering the document filed therewith, finds that there are materials to proceed further and giving rise to reasonable suspicion that the accused would have committed the crime, then the court shall frame charges. Please kindly read the section 228. If after such a consideration and hearing as aforesaid means as said in section 227, the judge is of the opinion. Here please kindly consider this is not finding. Here it is only opinion, not finding at all. So there is no adjudication, there is no analysis, there is no evaluation, there is no weighing of the evidence. At this stage, what the court does is forming only an opinion. What is the opinion? Opinion that there is ground for presuming. So there are grounds to presume. The court has to form an opinion. What is the opinion? That there are grounds to presume. To presume what? Presume that the accused has committed an offense. So from out of the materials, if the court is of the opinion that there are grounds to presume, not proof, mere presumption, that the accused would have committed the crime, then the court shall frame charge against the accused. This is what we call as framing of charge. This is an important stage in the case under section 228, framing of charge. Now, suppose on such examination, if the sessions court finds that there is no offense which is exclusively triable by court of session, then what the court has to do? That is dealt with in subsection 2, which says, if the session judge finds that there is no offense which is exclusively triable by court of session, then the court of session shall transfer the case. Here you please kindly see the language, transfer the case to the chief judicial magistrate or to any other judicial magistrate having jurisdiction to try the case according to law. So at that stage also, the session judge can return the case, that is transfer the case. Now, 3 terms I have used, I have highlighted to you. Number 1, commitment of a case. That while dealing with section 209 and 323 CRPC, I told you as to what is commitment. That is commitment of a sections of a case. Then while dealing with section 193 and 194 of the code, I said making over of the case by a court of session to the additional session judge. That also I have to second term. Here the term used is transfer. So there is a vast difference. I believe that now you understand there is a difference which is very vast between these 3 terms. One commitment, the other one making over, and here it is transfer. So if the session judge finds that there are no offenses available from the record which is exclusively triable by the court of session, then the session judge shall transfer the case to the file of the chief judicial magistrate or the judicial magistrate concerned. Friends, before 2006, as per this provision 228B, the law was that if the case is found to be not exclusively triable by the sessions court, the sessions court shall transfer the case only to the chief judicial magistrate, and it is for the chief judicial magistrate alone to try the case. That was the law before 2006. Now, by amendment which was brought into force on 23/6/2006, now law has been made by amending this subsection A to section 1, that the session judge may transfer the case either to the chief judicial magistrate or to the judicial magistrate who actually committed the case. There the case will go back again. This is an important stage in every sessions trial. Now, section 228 simply says that the session judge shall frame charges. All right. What are the charges? What is a charge? How it is to be framed? For that, you have to come to section 216 onwards. I'm sorry, 211 onwards. That is in chapter 17 of the code. Please turn to chapter 17, section 211. So I have told you that under section 228, the session judge shall frame charge. How to frame charge? That is dealt with in this chapter 17. Section 211 says as to what are the contents of the charge. Then section 212 says particulars as to time and place and person. Then 213 says when the manner of committing the case is to be stated in the charge, and it goes like that. So charge means putting to the accused that you have committed this crime by killing so and so person or doing this. Therefore, I charge you like this. And without more reading all these things to you, I can show you a form of charge that will give you a clear understanding of the same. In Schedule 2 to the Code of Criminal Procedure, Form 32 has been given with reference to Section 211, which I read now, that is contents of charge. Section 212, particulars as to time, place, and person. And 213, when manner of committing the offence must be stated. How all the three should be combined in the charge is shown as an illustration in the form 32. Please kindly go to the last part of the CRPC, where in Schedule 2, various forms are given. Go to form number 32. So this is a model charge. See how it is done. I, so and so. I means I. Suppose I am the judge. I will say I, Nagamuthu, the principal session judge of Tanjavur. Hereby charge you, dash. You means you. Suppose let us say that he is one Krishnamurti. We will say I, Nagamuthu, the principal session judge, hereby charge you, Mr. Krishnamurti, as follows. How? On that you, on or about so and so date and at so and so time, waged war against the government of India and thereby committed an offence punishable under Section 121 of the Indian Penal Code. So here charge is framed under section for the offence under Section 121. See how the wordings are couched in this regarding the charge. Similarly, there are other forms given for various other offences as well. So this is the way in which charge is framed by the court under Section 228. Charge is nothing but putting the accused on notice as the accusations against him and the offense for which he is charged and he is going to be punished if proved. For example, I charge you for offense of murder. I charge you for the offense of theft. I charge you for the offense of kidnapping. I charge you for the offense of abduction of so and so person on so and so date at so and so place and to so and so place. Abduction. So this is the way in which a charge used to be framed by the court under Section 228 of the code. So if you want to understand Section 211, 212 and 213, please first read this schedule and know the form of charge. That will give you a clear idea as to how a charge used to be framed by the court. My dear friends, framing of charge is an important stage. That is why I am repeatedly impressing upon you, because one hurdle is passed by the court and the accused is put under neck now, under a noose now, by framing charge against him. Now this is Section 228. Now, after charging the accused, the charge should be read over to the accused. After framing of the charge, it shall be read over to the accused. So please, accused, know that this is the charge which I have framed against you. What do you say? So that opportunity is given to the accused. Now, the next provision is Section 229, which states that the accused may plead guilty. Suppose as a judge I tell, I charge you for murder, I charge you for abduction. What do you say? The accused may say, yes, I plead guilty. You know, Mahatma Gandhi ji pleaded guilty before the court. He did not defend. He said, yes, he pleaded guilty. Like that, the accused may plead guilty. If he pleads guilty, yes, I committed the murder, he pleaded guilty. Can we convict the accused immediately on such plea? Please kindly look at Section 229. If the accused pleads guilty, the judge shall record the plea. So the judge has got no option but to record such a plea. The judge cannot refuse to record such plea. So you have to explain to the accused that these are all the charges which I frame. What do you say, whether you plead guilty or not? When the accused says, yes, I plead guilty, the court has got no option but to record such a plea. The court shall record the plea. After recording the plea, what the judge has to do, that is the latter part of the same provision, which says, in his discretion, convict him thereon. This language, in his discretion, was not available previously. It was inserted later in this code. So a discretion is given to the court either to convict him or not to convict. Though the accused may plead guilty, the court may, in its discretion, refuse to convict him. So it is not mandatory to convict the accused at all at that stage. Mr. Bhargav, I will close in 2 minutes. So for this, how the discretion used to be used by the courts is dealt with by the Honorable Supreme Court, where the Supreme Court says that in every case which is triable by court of session, don't use your discretion to convict the accused on such plea. Record that plea, go ahead with the trial, examine the witnesses, and finally you give judgment not only based on this plea. The plea will be one of the factors to be taken into account. This was the law laid down by the Honorable Supreme Court in in 1979 2 SEC, page 409. So the court is not bound to convict the accused immediately on such a plea, on the admission made by the accused. The court has got discretion. How the discretion used to be used? The Supreme Court has guided the session courts that because you are dealing with serious cases involving capital punishment as well as life imprisonment, don't punish the accused, don't convict the accused on the plea of guilty alone. Use your discretion not to convict him, and please kindly proceed with the trial by examining the witnesses. So this is one stage now. So the accused, if he does not plead guilty, then the court shall fix a date for examination of witnesses. This is the first part of the trial. Please, my friends, I want to put it in a nutshell. As to what we have covered, I am going to close. As far as my first part of my lecture is concerned, case originated in the police station by registering FIR. It culminated in a final report before the magistrate. Magistrate took cognizance under 190 CRPC. Then he committed the case under 209. It has come to the Sessions Court. Sessions Court has taken cognizance under 193. Then after taking cognizance, trial starts. The proceedings before the Sessions Court starts. The case is to be opened by the public prosecutor. He has to narrate the case and the evidences that are there in his hands to produce. Then after that, the court may discharge the accused if there is no material. If there are materials to presume that he has committed a crime, the court will frame charges. After framing charges, the charge shall be read over to the accused and asked to him as to whether he pleads guilty or he wants to be tried. If he pleads guilty under section 229, the accused, the court has got discretion to convict him, but the Supreme Court, by a cutting of judgment, has said, don't convict on such plea. There are sufficient reasons for holding so. What are those reasons? I think that my time is over, therefore I am not saying this. I will tell you in the next hearing why the Supreme Court was forced to say that don't convict on the plea of guilty immediately. Then if the accused does not plead guilty and wants to be tried, then the Sessions Court shall fix a date for examining the witnesses. So the actual trial before the court of session starts after the framing of charges. Until then, only pre-trial proceeding. The trial commences only after the charges are framed. How it is conducted, how witnesses are examined, who are all competent to speak before the court, how they are appreciated, how argument is heard, how judgment is delivered will be in my second part of my lecture. I think that with this I can conclude. Thank you very much for having given me this wonderful opportunity. And if there are questions in respect of this first part from the students, I am prepared to answer. Thank you, Mr. Bhargav. Over to you, Mr. Bhargav.
Thank you very much, sir, for invigorating, elucidative, and completely interesting talk on the making of the sessions trial part 1. And probably we can take the questions from the students for both this part and the next part together during our next lecture on the 17th of October as part of Jus As They Teach. And I must profusely thank Justice Nagamuthu for this lecture for the primary reason that there is no substitute to practice or practical learning at the magistrate court level and at the sessions court level in the criminal side. There can't be any substitute to that. And it is people like Justice Nagamuthu who inspire generation of students to take to this area of practice. And it was a completely invigorating talk and we enjoyed every bit of it. And I must add that more than 200 viewers have seen this lecture in the last 1 hour, which shows the value and the critical nature of the subject itself, the sessions trial, which is the mainstay of the criminal procedure code. And once again, let me, on behalf of the faculty, the management of SASTRA University and its School of Law, the students, thank you, sir, for spending this 1 hour with us. And thank you once again. Thank you.
Thank you, Mr. Mayor.